Good evening. Today is March the 30th, 2017. I am Karen Harding. I am a criminal defence lawyer from Auckland, New Zealand. In this context, I'm talking to you about litigation that I'm involved with as counsel in relation to plaintiffs in an employment court case to deal with slaves at sea. I have 30 Indonesian fishermen that I am representing who are taking action against the Sajo Oyang Corporation in relation to unpaid wages and personal grievances. In respect of this matter, there are 7 fishermen taking a test case at the employment court at Christchurch, and the case number is EMPC 6/2017. I am addressing you now about our application to transfer the proceedings to the employment court at Auckland. So I'm just going to go through some of those submissions. So the applicants are by normal occupation fishermen who are citizens of the Republic of Indonesia and reside in Indonesia. They do not speak English and require interpreters to assist with all communications. They have a low level of education and are impoverished. They are accordingly vulnerable persons who warrant society's protection to ensure they have access to justice. The Indonesian crew member plaintiffs need help to access justice as they face huge challenges to access justice and legal services. It was very difficult for the plaintiffs to get information on their rights under New Zealand law and to find counsel willing to accept instructions. When counsel was engaged, this was with a counsel based in Auckland. This is myself. The defendant has no assets or offices in New Zealand, and there is no means to enforce a court order in New Zealand over the defendant, the Sajo Oyang Corporation, to pay any wages, holiday pay, interest, damages, compensation or costs that the court may award. This is of concern obviously to us and is a factor in this litigation. The first and second plaintiffs are 2 individual plaintiffs from Oyang 70 vessel who reside in Indonesia who are fishermen, and they signed a 2-year contract to work exclusively for the defendant. The third and fourth plaintiffs are another 4 fishermen who signed on to work on Oyang 77 to work exclusively for the defendant, the Sajo Oyang Corporation, on Oyang 77 vessel in New Zealand on work permits. Pursuant to Section 103 of the Fisheries Act 1996, the owner of the vessel that is permitted to fish under quota in New Zealand waters with the approval of a principal to recruit foreign crew and AIP issued by the New Zealand Immigration to work on such a vessel is deemed to be the employer. Accordingly, the foreign crew working on the vessel are deemed to be employees of the owner of the vessel. Therefore, applying the applicable New Zealand law, the defendant, the Sajo Oyang Corporation, was the employer of the plaintiffs, being these 7 Indonesian fishermen and also the other 30 that I am acting for during the period of their employment on the Oyang vessels Oyang 70 and Oyang 77 in New Zealand. The plaintiffs were working in New Zealand and during that period of their employment they were entitled to be paid according to New Zealand law under the Minimum Wages Act 1983 for every hour they worked, including sleepovers, and also in accordance to the 2006 Code of Conduct for Foreign Fishing Crew, known as the 2006 COP, that applies an extra hourly rate per hour for every hour worked, and we say this also applies to sleepovers. I'm also submitting that they're eligible to be paid holiday pay and seek for that to be paid. The plaintiffs have claimed that they have not been paid their full New Zealand wage entitlements and holiday pay entitlements for every hour that they worked on the vessels, including sleepovers as per the New Zealand Minimum Wages Act 1983 and the Holidays Act. In addition, they claim they're not being paid their entitlements under the 2006 Code of Conduct for Foreign Fishing Crew and the extra hourly rates. Collectively, this is referred to short pay wage arrears. In relation to the 7 fishermen, due to the length of time they worked, the fact they had to work 24 hours a day on call and worked on average 18 to 20 hours per day over 2-year contracts each over quite a significant number of years collectively, we are seeking unpaid wages, including holiday pay, top-up wages and other money for wages of the sum of New Zealand $1,583,502.72, which we will be calling short pay wages arrears, for breaches of the New Zealand Minimum Wage Act, the Holiday Act and the 2006 Code of Conduct for Foreign Fishing Crew. These claims amount to very serious allegations against the defendant, the Sajo Oyang Corporation, in breach of the Minimum Wages Act 1983 and the Holidays Act and the 2006 Code of Conduct for Foreign Fishing Crew. There are sworn affidavits provided by each of the fishermen, including the 7 plaintiffs in this test case, that include allegations of forced labour. This is because of commencing employment with the defendant on the vessels. The plaintiffs found that they could not withdraw their labour without financial punishment occurring, and they worked under the menace of a financial penalty. The plaintiffs also claimed personal grievances, that the defendant as their employer treated them badly, and that the defendant required them to live and work in abject conditions on the vessel. Breaches by the defendant of its statutory duties under Section 12 Capital A of the Wages Protection Act 1983 are also claimed by the plaintiffs. The plaintiffs worked under a menace of a financial penalty, that if they resigned or were dismissed from their employment with the defendant, then the security that they were required to put up of their parents' land, property, houses and paddy fields, for example, and to guarantee their work on the Oyang vessels would be seized and confiscated by the Indonesian manning agents engaged by the defendant, the Sajo Oyang Corporation, to recruit the crew for their vessels. In addition, they worked under the threat that they would not get paid their wages that were being held as a security to the end of the contract. They were never paid. It is submitted on behalf of the plaintiffs that for the plaintiffs not to get paid the New Zealand minimum wages that they were legally entitled to created slave labour within New Zealand, which is a breach of the employee rights hard fought for in New Zealand. These employee rights do not diminish just because the labour force, which included the plaintiffs, was recruited from overseas and flown in from a third world country to crew a vessel in New Zealand waters that was owned by a foreign company. New Zealand rights applied, it occurred in New Zealand, they deserve protection. The claims are set out in the Statement of Problem on Authority Form 1 for the Employment Relations Authority, and then in the Statement of Claim filed in the Employment Court involve serious allegations of serious employment problems against the defendant, the Sajo Oyang Corporation, and the plaintiffs seek this court, the Employment Court, to resolve these issues. The plaintiffs submit that they can make out a case for a favourable exercise of a discretion under Section 219 of the Employment Relations Act 2000 for an extension to be granted for the filing of claims for the unpaid wage arrears and holiday pay arrears, collectively referred to as short pay, and in relation to the filing of personal grievances, so that the court should exercise its discretion to grant the extension to the plaintiffs that they have applied for under Section 219 of the Employment Relations Act, as the justice of this case requires it. There is a strong public interest in the case. Chapter 2. Transfer Application. Regulation 24(1)(2) of the Employment Court Regulations 2000. The plaintiffs deserve a full and fair opportunity to have their case heard at the court. The way to facilitate access to justice and to permit legal services to be delivered to an impoverished third world plaintiff who resides overseas is to keep the cost of litigation and related disbursements for travel and hotel costs as low as possible. This will involve having hearings at a location which is in the means of their legal services provider to be able to provide services to them, and at a hearing venue that will reduce the logistical difficulties, challenges and other communication barriers to their participation in the proceedings. The plaintiffs applied under Regulation 13(2) of the Employment Relations Authority Regulations 2000 for a transfer of proceedings to the Auckland office of the Employment Relations Authority, which the defendant, the Sajo Oyang Corporation, opposed. The defendant opposed a transfer application to make it easier for the foreign corporation and its yet unidentified experts and undisclosed documents that they might bring with them to make it easier for them to get to Christchurch. The defendant opposed the application for transfer, despite the fact the defendant is of significant financial means and able to organise its affairs anywhere in the world as a major international fishing company. To have hearings in Christchurch, particularly if the plaintiffs and their witnesses are to give evidence, causes huge obstacles both financially and logistically for the plaintiffs. To be able to participate in the proceedings and for their counsel to deliver legal services to them, that has a high propensity to obstruct the plaintiff's access to justice and to frustrate the delivery of legal services to them. The plaintiffs have been granted permission under the minute of Chief Judge Colhan on the 12th of January 2007 to apply for a transfer to the Employment Court proceedings to Auckland and to have that application determined on the basis of the interests of justice. Accordingly, the defendants are on notice that the plaintiffs apply under Regulation 24(2) of the Employment Court Regulations 2000 for the proceedings to be transferred from the Christchurch office of the Employment Court to the Auckland office of the Employment Court. Regulation 24(2) of the Employment Court Regulations 2000 states as follows: the registrar of the court, of his or her own motion and on the application of any party, may direct the transfer of any proceedings, including the proceedings of any offence, from any office of the court to any other office of the court. Despite the objections of the defendant, a transfer to the Auckland office of the Employment Court is appropriate, and in the particularly unusual circumstances of this case, in the extreme impoverishment in relation to the plaintiffs who seek their unpaid minimum wages. It is submitted that the overall justice of the matter requires the plaintiff's substantive claim for wages and personal grievances to be heard and determined at Auckland, and that accordingly the transfer application should be granted by the court. Section 3. Transfer application to Auckland and exploration of the issues raised. The plaintiffs apply under Regulation 24(2) of the Employment Court Regulations 2000 for a transfer of the proceedings to Auckland. This regulation reserves the court a residual discretion that may direct the transfer of any proceedings to another office of the court. This regulation does not specify any criteria or factors that need to be considered when exercising the discretion. The discretion to be able to transfer proceedings is a recognition by the legislator of the need to allow for flexibility. The Employment Court, when considering a transfer application, should deal with each application on its individual merits on a case-by-case basis. Matters such as convenience and costs are relevant to the exercise of the discretion of the matter. I refer to the case of the Department of Labour Immigration Service v Camo, Employment Court, Auckland, 74/043 March 2004. The applicant, Mr. Camo, resided in Samoa where the events of their problem occurred. He had been working for the Department of Labour in Samoa and lodged his application at the Auckland office of the Employment Relations Authority. The Department of Labour challenged whether that application had been lodged at the correct office of the Employment Relations Authority under Regulation 13(1) of the Employment Relations Authority Regulations 2000 and applied to transfer the proceedings to Wellington where they were based. The department wished to call at the investigation hearing 2 to 3 witnesses who were all Wellington based, and a meeting at Auckland would have increased the Department of Labour's costs. In that case, the authority determined that Auckland was nearer to Samoa than Wellington, and that therefore the application had been properly lodged at the Auckland office. The department's application to transfer the proceedings to Wellington was declined because the authority accepted it would add significant cost to Mr. Camo in the proceedings, because Mr. Camo would not have to fly himself and 2 witnesses from Samoa to New Zealand, but he would also then have to fly his counsel to Wellington from Auckland, and the cost of accommodating his counsel in Wellington. It was not considered realistic for Mr. Camo to be able to instruct other counsel in Wellington to save on costs. The authority in that case said, "I consider that it is appropriate to weigh the relative hardship to the parties of an investigation meeting in Auckland, since both parties, with respect to the department, its witnesses, are not resident in Auckland. On balance, I have reached a view that to grant the application would be more harshly on Mr. Camo than it would on the department if it were declined, and I have reached the view on that basis that Mr. Camo's financial resources are relatively more limited than those of the department. Accordingly, I submit that the financial resources of the respective parties is relevant to considering the plaintiff's transfer application. The plaintiffs reside in Indonesia and lack the financial resources to participate in court proceedings in Christchurch and to pay for the costs of hotels in Christchurch. There is an evidential foundation for the submission of lack of financial resources found in the affidavits of the plaintiffs that were sworn and filed in support of a fee waiver application at the District Court at Christchurch in respect to the Section 256 Fisheries Act 1996 proceedings, seeking the relief from the effects of forfeiture from fishing vessels Oyang 77 and Oyang 75 that were forfeited for fishing crimes from their employer, and they seek their unpaid wages out of those vessels. The plaintiffs face unique and special challenges and barriers to accessing the New Zealand justice system that makes the delivery of legal services to them very challenging and are not issues of concern for the defendant. There are extremely high costs for the plaintiffs to engage in litigation in Christchurch, take into account their impoverished financial situations and that their counsel is located in Auckland. Counsel for the plaintiffs is a sole practitioner in a very small firm in Auckland that specialises in criminal and traffic law. It will be challenging for counsel to fund costs for hearings in Christchurch. The costs that the plaintiffs would face if the proceedings remain in Christchurch are as follows. 1. The costs of return national airfares from Auckland to Christchurch, excess baggage fees, hotel accommodation, taxis and meals while outside Auckland for Counsel to attend every court appearance and for all subsequent appeals. This is a significant cost of many thousands of dollars in disbursement costs if proceedings remain in Christchurch, where in Auckland no cost will be incurred at all for Counsel for those disbursements in Auckland. B. In addition, the plaintiffs face additional costs for airfares, hotel accommodation, taxis, meal costs and related disbursements, expenditure for every single witness the plaintiffs wish to call to give evidence at the hearing. On top of those costs for getting counsel and the witnesses to Christchurch for the duration of the hearing is the cost of the plaintiff's own costs for international travel to New Zealand and then national travel within New Zealand, which will be many thousands of dollars, plus hotel costs, meals and other costs, which in total will be tens of thousands of dollars, plus legal fees. So huge costs are involved, hundreds of thousands of dollars involved at least. And there are witness fees and hearing costs to pay. Translations, interpreters and Indonesian legal assistants are needed to be available on a 24-hour, 7-a-day basis to communicate with the plaintiffs when they are in New Zealand. Counsel is better able to organise the provision of translating, interpreting and facilitating that at a more reasonable cost in Auckland than in Christchurch. The plaintiffs also need access to a mosque and a prayer room for prayers. They also have special dietary needs to comply with their religion, and counsel can best facilitate their care in Auckland. If the proceedings were transferred to Auckland, hotel accommodation will be slashed or not incurred at all, as other accommodation arrangements such as homestays are highly likely to be available to accommodate the plaintiffs in Auckland, and there would be no other internal national air travel costs for the plaintiffs, the witnesses and expert witnesses, or for their counsel. Collectively, the above-mentioned special circumstances amount to very significant and unusually exceptionally high challenges to the plaintiffs to overcome to participate in the proceedings in Christchurch. The transfer to Auckland is necessary to facilitate the access to justice and to enhance the delivery of legal services to impoverished, non-English speaking litigants who require interpreting assistance to communicate with counsel. Therefore, retaining proceedings in Christchurch would create a huge unfair financial burden and obstacles for the plaintiffs that they could not overcome. Also, as events occurred at sea and the vessel Oyang 70 sank, there is no scene to visit in Christchurch. The defendant is a large corporation with huge financial resources. The defendant is instructing a specialist litigation team operating out of Nelson to represent its interests and can afford to pay their expert witness their fees, expenses and disbursements. The defendant simply does not have the same resource difficulties, challenges and barriers to overcome that the plaintiffs do to access justice and legal services. If the defendant wishes to call their witnesses, any expert witnesses who are based in Christchurch, they could give evidence on audio-visual link if they wished, or as responsible business people who speak English, they are capable of getting themselves to and from court or an AVL suite or on a plane and paying for it without any difficulties, and with the defendant being able to pay for those without causing the defendant undue hardship. So there is a huge disparity of resources between the parties, between the fishermen and their employer, and the court needs to consider that in the interests of justice. Relevant to the exercise of this discretion are the provisions relating to equity and good conscience. A transfer is necessary in the overall interest of justice in this particular case, as the financial circumstances of the plaintiffs require it to ensure access to justice and to allow for the proceedings to be heard and determined. The public interest merits in this case being heard are also high. The justice of the matter requires the plaintiff's substantive claim for wages and grievances be heard and determined. And accordingly, the court should err in favour of allowing the plaintiffs to have their case heard in Auckland. Thank you. I'm counsel for the plaintiffs, and this was dated the 31st of March 2016 on notice to the file manager at court at Wellington Employment Court and to counsel for the defendants based at Nelson. Thank you for your attention.